So what I will do is to show how public procurement measures have been excluded from free trade agreement. And then the second component will be to try to explain why they have been excluded. So generally, before we go to the next slide, exclusions are done very generally, excluding all forms of procurement from free trade agreements being applicable to them, or exclusion is limited to government procurement that are made for governmental purposes and are not meant for resale. So this is the nature of the exclusion, or these are the nature of the exclusion that we find in free trade agreement. Can we go to the next slide? So I try to provide two ways of explaining why procurement is excluded from regional free trade agreements. And one of them, and I think Chris made reference to that, protectionism. Basically, governments don't want to make sure that the procurement market is preserved for the participation of their nationals, even if that kills competition and ultimately affects the achievement of best value for money. But having also done some extensive research in the area of investment treaties, investment treaty arbitration, and recently published a paper looking at the intersection of public procurement law and international investment law, I think one of the reasons for the exclusion is to ensure that governments avoid foreign participants in the procurement process who may qualify as investors, suing them in international arbitration. That if procurement measures were to be qualified as investment under investment treaties and the free trade agreements, then that will open up the possibility of governments being sued in international arbitration. So these are the key ways that I try to explain the exclusion of public procurement in regional free trade agreement. Can we go to the next slide? So I'll give you a sample of cases in which public procurement has been excluded. So we can take, for example, the Regional Comprehensive Economic Partnership Agreement, which is signed by the Association of Southeast Asian Nations. If you look at the Article 10.2.2, it says that the investments chapter shall not apply to government procurement. And then if you look at the Trade and Cooperation Agreement between the European Union and the European Union Atomic Energy Community and the UK, it also provides for the exclusion of the Services and Investment chapter from being applicable to public procurement. Then again, if you look at the US, Mexico, Canada agreement, it provides for the exclusion of national treatment, the most favored nation treatment, and the provisions related to the appointment of senior management and members of the board of directors from being applicable to government procurement. Can we go to the next slide? And then, of course, we also have the agreement establishing the African Continental Free Trade Area in Article 2.4. It provides a trade, the chapter or protocols dealing with trade and services do not apply to government procurement. And then the free trade agreement between Canada and the European Union also excludes a number of provisions of the agreement or chapters from being applicable to government procurement. So that allows us to establish the point that indeed these regional free trade agreements do actually exclude government procurement from being within the scope of the application of those agreements. Can we go to the next slide? So I think, and as I argued earlier, that the basic idea of these exclusions, quite apart from the point that Chris missed earlier, is to ensure that states do not tie their hands such that they get sued in private arbitration by bodies that investor-state arbitral tribunals are not necessarily accountable to anyone. And you can imagine that government being seeking to procure goods and services or works for the national need, and then they get sued before private arbitration. That is likely to really distract government from being able to perform their core functions. And so it is possible that procurement, the subject matter for procurement can actually qualify as an investment, because the concept of investment is defined very broadly in free trade agreements that contain investment chapters, or even in bilateral investment treaties. So if we take, for example, the Energy Charter Treaty, it defines investment to mean every kind of asset owned or controlled directly or indirectly by an investor. So again, the monies and resources that the foreign investor will put into the procurement process may well qualify as an investment. So the expenditure that the procurement entities will, will not procurement, the suppliers will incur may well qualify as an investment. And so if that qualifies as an investment, then they've got to be given equal opportunity and equal protection under free trade agreements with investment chapters and bilateral investment treaties, so that any form of discrimination against foreign participants in the procurement process can be challenged, and that treaty terms such as the fair and equitable treatment standard, and even provision that specifically prohibit discrimination against foreign investors. Can we go to the next slide? Again, there is the potential that the very nature of the methods used for procurement are such that they are most likely to clash with the core terms of free trade agreements, specifically relating to investment. National competitive tendering, for example, essentially requires that you limit the participation in the procurement process to citizens or nationals of the country that is seeking to procure. Restricted tendering gives procurement entities the discretion in terms of who they invite to participate in the process. And so in making a decision to use restricted tendering, for example, the procurement entity might decide to limit participation to national procurement suppliers. Again, that would mean that foreign investors will be excluded from participating, or foreign suppliers will be excluded from participating in the process, because these two methods of procurement, by their very nature, are exclusionary. And so, again, that can lead to a clash between the implementation of domestic policy, domestic law on procurement using these methods with terms such as fair and equitable treatment standard and the national treatment standard and the international investment treaties. Can we go to the next slide? So in this case, for example, the tribunal, in the case of Bosca against Lithuania, the tribunal held that the decision of the government or the state entity to not award a procurement contract to a foreign investor was made in bad faith and contrary to the investor's legitimate expectation, which constituted a breach of the applicable investment treaty that provided for fair and equitable treatment standard. So the essence of this decision is that if the procurement process is not open enough for participation for eligible international investors or suppliers, then they have protection under they will have protection under the relevant international investment treaty or free trade agreement with investment chapter to challenge the state. So again, it shows how states want to avoid the risk of being sued in international arbitration for adopting measures that are allowed under domestic legislation. Can we go to the next slide? Again, procurement, here we are talking about, again, the clash between the quest for states to pursue preferential procurement policies and their obligations under international, free trade agreement. And South Africa is very known for policies around that, which are not just policies, but also they are constitutional in nature, requiring that procurement be used as a tool to address various socioeconomic goals. So, and they impose various requirements that are intended to include domestic participants in the procurement process. And preferential procurement policies are most likely to clash with, maybe I should make reference to the broad-based socioeconomic empowerment chapter of South Africa, for example, which requires that a certain minimum of total money goods be spent on South African manufactured goods. Of course, if it is a foreign participant that has manufactured, there is no issue there. But where it required that certain allocations be made to goods manufactured in South Africa, that is essentially made in South Africa imposition, just as we may have, say, made in America imposition, made in Australia imposition. Now, these impositions can have implications for, can conflict with investment treaty terms, such as the prohibition against performance requirements, which say that don't make imposition, for example, on how many goods must be imported or must be exported and so forth. So again, a country that wants space to implement some of these, preferential policies will be very mindful of including, public procurement within the scope of application of, the free trade agreement or even bilateral investment treaties. Indeed, South Africa was sued by foreign investors, Forestry against South Africa. That case was eventually settled, all right. But they related to some of these measures relating to preferential procurement policies. Can I see what I have in the next slide? All right. So basically, again, there is another method of procurement. Single source for procurement, for example, requires that you engage maybe in an emergency or urgent situation. You engage certain specific procurement or supplier. But if we look at the procurement policies of Ghana, in particular the Public Procurement Act of Ghana, the single source procurement is not just a tool to be used when there is an urgency, but also to promote certain national development priorities. And so, again, the state might decide that, well, I want to engage a local supplier because that is what I can use single procurement in order to promote those socioeconomic goals. And if you look at the requirement for the use of that method and make reference to the balance of payment position and foreign exchange reserves of the country, It talks about the counter-trade arrangements offered by the supplier or contractors. It talked about the extent of the local content and so forth. Clearly, you cannot have, your procurement policy pursuing these very good national goals without clashing with the terms of investment treaties. So the point that I'm making in conclusion is that, one, states are seeking to preserve the market for the procurement market for participation by local suppliers. But that may not well necessarily serve the needs of the procurement system, where, for example, they are not in a position to effectively supply what is needed. But also, they are seeking, most states, in seeking to exclude it, essentially want to preserve their regulatory autonomy when it comes to the implementation of their procurement policies. I think I should end here and we can have better conversation. Thank you.